Thank you. Please be seated. Good morning. We're here for oral argument in case number 19-0130 Easy Homes Inc. versus Brian Loiselle. Am I saying that correctly? Counsel, ask you to please identify yourselves and declare at the beginning of your arguments. Counsel for appellant, you'll have 20 minutes to present your argument. Please watch the clock and make sure you reserve as much time as you'd like for rebuttal. Please keep in mind we've read the briefs and copies of the case, so familiar with the basic facts and not every fact, I say that, but the basic facts of this case. So with that, counsel for appellant, you may proceed.
Thank you, Your Honors. May it please the Court, my name's Al Arpad. I represent the defendants and the appellants in this case. I'd like to reserve, say, around 4 minutes for rebuttal because this has gotten a lot more complicated. I apologize, I do have a cold today, so I hope my voice holds out. I thought this was a pretty simple case when I took it. It was just, as my predecessor counsel stated several times in oral argument and elsewhere, does this property description describe these condo units, or are they not part of the property description? If they're part of the property description, Easy Homes wins. If they're not part of the property description, my client wins. As you know, the properties were sold at a trustee sale.
And why is that the question? Why isn't the question, is the notice of sale adequate?
That simply isn't how the case was litigated. I suppose that it could have been, although then...
That may be how the law is. I mean, to some extent, the litigants are the masters of their own case, but ultimately the law is going to get us all. So I don't understand why we should immediately accept the premise that the precise language of the legal description is dispositive of the issue.
I don't know what else can be dispositive of the issue, Your Honor. We've quoted a number of cases from the Arizona Supreme Court saying that deeds of trust and trustee deeds have to be interpreted strictly. And
well, timing could be dispositive, right? I mean, there's also the notion that you need to try to enjoin a sale before it happens, not challenge it after. I don't understand where the authority is that says the inclusion of a few words relating to the plat are critical.
it is critical because this is a condominium. I think we agree with 95% of what Easy Homes has said if we were talking about flat plats. They can be somewhat interchangeable. You record another one, you could theoretically still convey something as to the old one. But once you create a condominium, you no longer have a situation where conveying one level, the flat ground, also conveys the thing sitting on top of it. It simply doesn't. Now, let me get back to what I think you were asking originally. Maybe I'm wrong about this, but I think what you were asking was, why wasn't it litigated as a challenge to the sale? And the answer is it simply wasn't. I mean, Zubia and all those other cases would tell us if we intended to challenge the sale, for the most part, we had to do it ahead of time. We didn't do that. And my predecessor counsel said over and over again, that's the premise of the case. Whatever they bought, they bought. He phrased it, I think, rather inexactly as they bought the parking lot. There's a residual question that somebody's going to have to answer at some point, unless you hold that what they bought was everything. What does it mean to buy a parking lot of a condo? I think
you lost me a little bit back there when you said it wasn't litigated like this. Well, Judge Stevens specifically found that your clients waived all claims and defenses when they failed to challenge the sale by filing an injunction. She brought that up on her own?
No, the other side did in fact say that, and we argued it was not applicable. Our theory of the case, and the way the case was litigated by my predecessor, was we are not challenging the sale. Whatever was sold was sold. We admit whatever was sold, but it didn't include these two parcels. That was the premise.
The parcels or the structures? Because in a condominium, it's possible to sever the land and the improvements. So did they buy the parking lot and some of the adjoining land on which the improvements sit?
I think many of the people involved in this back in the 2000s, shortly after the condominium was created, thought that they had. But in fact, as a matter of law, they hadn't. Once you create, and I didn't quite understand what you were saying as the beginning premise there, but once you create a condominium, no, you can't really sever off the land. The land's part of the condominium. It's jointly owned by everybody. You'd have to join all of the owners in order to take away their interest in that land.
And how do you sever the condominium in the common area?
Generally, do you mean sever
Oh.
in terms of creating the condominium, or do you mean sever in terms of sell
That's
them
a practical matter of sell it. Practically, you want to offer for sale. Here's 2 condos, but you'll have to fly in on a helicopter in order to access.
off? That's
your
exactly
condo.
right, Your Honor. That's why you can't sell off the parking lot of a condominium. There is a question whether Easy Homes bought anything because you can't sell off the parking lot of a condominium. But that wasn't decided because the trial court decided something different. It decided that everything had been sold.
And what's wrong with that?
You
Well, yeah,
can't
let's say
simply sell a piece of property out of a condominium. And the improvements on parcel 7C, once you've declared the condominium, are maybe the curb, gutters, something like that, but it's not the buildings. Those are separate parcels of real estate that are adjacent real estate. They are not improvements on Lot 7C. They are not part of Lot 7C. They are condominiums. They are floating above Lot 7C. They are vertically adjacent instead of being horizontally adjacent. And that's why trying to use meets and bounds simply no longer works, because as we all learned many years ago, meets and bounds go up to the sky and down to the center of the earth and include improvements and things like that, and they simply don't anymore once you have a condominium.
Educate. You have a construction lender participating in parts of the condominium construction project. Soil compaction, common areas, and flooring pads for units. That isn't paid. What's the remedy?
That depends on what time this happened and who hired them and whether the condominium has gone into effect. If we're talking about very early in the process and the condominium hasn't gone into effect,
Let's assume it's completely in effect, occupied, doing its
it's an interesting question. If you go back to when, for instance, the McKeever case was decided, they're talking about the possibility that the board, nobody has the ability to alienate the common areas anymore. You just can't. So there have been some refinements in the 90s and the 2000s in both the Condominium Act and in the way condominium documents are written, so that usually there is somebody who has the residual authority to alienate, whether that's incur a lien on or sell. Usually it's pretty limited ability to sell because nobody would buy a condo if they thought the common areas could be sold out from under them. Condos would go out of business if that was a common thing to happen. But typically, and in this case, if you look at the declaration, which the other side says you shouldn't, but you can see that there's initially somebody who's named as a declarant who has some limited ability to alienate the common areas, and later on the condo association has some limited ability to alienate the condo areas. So assuming that that's who hired this person who's doing whatever construction, they probably can incur a lien on that property. But if a unit holder does that, no, they don't. The unit holder simply does not have the ability to alienate the common areas.
Help me understand. Why would Capital Fund loan $300,000 on this property? What were they getting in return? What was the security? What was the collateral?
There is no dispute that everybody intended them to have a lien on the property, as the term has been loosely used, meaning 1355, I think it is, Greenfield Road.
So
Everybody intended that.
everything. I mean, including the office, including the condos, the common area, the parking lot, everything.
Yes, my clients intended to pledge their interest as collateral for the loan. The problem is nobody at any stage of this, and that's why this is an important case, understood what that property description actually conveyed. And so at the end of the day, after the sale, you are stuck with a problem. We are all stuck with a problem.
Is this a drafting error? or is this a mutual mistake? Did parties think that they were talking about different definitions of property?
I think that's true, Your Honor. I wasn't there, but I think they did. And that's why there's a statute of limitation issue that comes up, because mutual mistake is specifically what that statute of limitation says you can't bring up after 3 years. So at that point, the lender's stuck with what they're stuck with. Now, if they had perhaps gone into a judicial foreclosure, which you can do with a deed of trust instead of doing non-judicial foreclosure, perhaps a judge would have been able to sit down and think of an equitable resolution for this. And in fact, I think what would have happened is that my client would have refinanced and he would have gotten his property back and we'd all be fine. But that's not what happened. What happened is you had a strict non-judicial foreclosure, and in that situation, they bought what they bought.
Is there title insurance on property?
There was title insurance. The title insurance on a trustee's sale is very limited. Prior to that, there was title.
No, I mean associated with the loan.
With the prior, yes, and that's the whole thing is alarming, frankly, because everybody, the original buyer, one of the guys who dedicated this condominium, my client, the title company, the lender, all kinds of people misunderstood how condominiums, how a condominium description works, and you had this description being conveyed out after a condominium that had been formed that couldn't, as a matter of law, convey property out in fee.
Go back to so Mr. Loiselle, or the Loiselles, they knew that the property needed to be, that the lien included everything.
They intended originally.
They intended, okay. So why are they able to back away from that intent and say, well, wait, we intended to do that, but now, wait a second, we're finding a loophole, and now we want to take it.
For the same reason in the Pheasant Grove case that this court held, that after 3 years you don't get to go back and reform the thing based on intent. You have to live with what the document actually says. That, again, was a story of two adjacent parcels. There was never any question. The people had a house on the two parcels. There was never any question that they intended to mortgage it. But years after the fact, even though the lender had knowledge of what the description should have been, the lender wanted to say, well, give me both parcels. I only had a mortgage on one, but I want both. And the court said, sorry, you simply cannot go back and reform after the statute of limitations has expired. So they've got what they've got at that point.
I'm going to refer to your reference earlier as the floating argument. The floating argument. You said that condos float. Legally speaking, they float above the ground. Did you make that argument to Judge Stevens? I mean,
yes, it's made most extensively in the oral argument, but it's also pretty clear in the briefing, I think, is that these are separate parcels that are I don't think he used the word floating, but they are separate parcels that are vertically adjacent. And that's the problem. They're within the boundaries if you only look at the flat part.
So is the trustee then, should the trustee be nervous?
No, because the trustee went out of his way to say, do not buy this property if you don't know what you're buying. I think the trustee knew perfectly well that there was a problem here. The trustee knew that there was risk involved in this. The trustee put one tax parcel, which is the flat parcel that definitely doesn't include the condos, as the tax parcel he thought he was selling. Now, there are stipulations as to what the trustee said. They don't go into his subjective intent. But I think the trustee was very careful to say, don't buy this unless you know what you're buying. And by the way, if nobody had bid, this would have come down to being between the lender and the mortgagor instead of being a third party that went and bought something that turned out to be not what they thought it was, and something that could have been sorted out at that point. But
how could it have been sorted?
Because my client made all his payments. Again, the other side is the side that has wanted to turn this into an equitable argument after the appropriate time frame for that. This was briefed as a legal argument on stipulated facts. So I'm not the one who wants to go down the equitable alley. But in fact, the equities would be on my side if you decide to send it back for that. My client had made his payments. My client was prevented from refinancing at the last minute by somebody who's not even here today filing an improper lease pendants on the property. And that's why he lost the property. It's not because he's a bad guy. It's not because he didn't make his payments, anything like that. And so he could have refinanced this given some more time. But somebody decided to go and do a strict foreclosure instead, and as a result, we all have to live with whatever the result of that strict foreclosure is.
Why was your client was not prevented from seeking an injunction to stop the sale?
There are some complicated reasons why my client did not seek the injunction, having to do with court scheduling and having to do with thinking that he had cleared the lease pendants already and had the financing ready and some other things like that. And again, none of that's in the record because the result, I think, if this had been pled as an equity case, is that nobody would have gotten summary judgment and we would have had to have a trial about that. Neither side wanted that, so they agreed to stipulate to basically all the facts and file this as cross motions for summary judgment because they both thought they were right about what the property description meant. I'll reserve my time if you don't have other questions. Thanks.
Thank you.
Hello, I'm Daryl Manhart. I represent plaintiff Applee Easy Homes, Inc. And what I'd like you to do, if you'd let me start with this, is pretend the condo plat doesn't exist. The plat that was recorded in 2005, pretend that doesn't exist. The case doesn't involve any third party claiming that it acquired title to that duplex building at some point in time prior to or outside the chain of title. The quiet title action presented a question as between the plaintiff and the defendants who was entitled the title to that office building. The defendants filed a motion for partial summary judgment as a cross motion to my client's motion. And on the first paragraph of that, it's item 105 in the record, defendants state if the legal description on the deed of trust included the condominium units, the plaintiff wins. The second paragraph of that same response has defendants saying, to resolve this dispute, all the court needs to do is interpret the plain language of the deed of trust. The opening brief in this appeal, page 41, states, defendants concede that Easy Homes purchased whatever was described in the deed of trust at the trustee's sale. They're talking about the capital fund deed of trust. So go to the capital fund deed of trust. Quiet title action, the court is called upon to interpret that document. That document says that it's secured by the land described on the plat recorded at book 658, page 28. There is a map, a plat recorded at book 658, page 28. It's the November 2003 plat. It's a conventional plat. The deed of trust also has specific language in it that says it includes all property or all improvements on that property. So if you're looking at the deed of trust as defendants presented to the lower court and this court saying that's what determines this, that deed of trust says that what secured the loan to capital fund was the real property described on that specific plat which exists, and the law says that for that conventional plat, when you make a conveyance, it includes all improvements on the land, and this deed of trust includes specific language that says it's intended to include all improvements on the land. So if you're interpreting that deed of trust, as defendants have told the lower court and this court, it includes the duplex building that's on that land. When they ask you to go look at the condo plat, the 2005 plat, they're looking at something outside of the deed of trust. It's extrinsic to it. That's not the rule of construction. You only construe a document according to what's there unless it's ambiguous. There is nothing they have ever argued that's ambiguous within the document. They've not pointed to anything in the deed of trust to say it's ambiguous. That's the end of the analysis, or it could be the end of the analysis. Another way to look at it is something that didn't come up during the first part of this argument here, which surprises me, which is look at the chain of title through which defendants Loiselle and his entities claim. There is not a single deed that refers to that 2005 condo plat. The only claim they have to the office building is a 2005 deed recorded after the condo plat and not referring to it. It refers to the exact same legal description that's in the capital fund deed of trust. And yet they say they bought the land and the building. If they bought the land and the building with that legal description, they used that same legal description in conveying it to Mr. Loiselle's trust, then back out of the trust to his entity, and then that entity used that legal description in encumbering it with a loan from capital fund, then whatever they had, that was extinguished when that trustee sale occurred. So if they ever owned the duplex building, they lost it at that sale. And if their theory is correct, though, which I disagree with, that legal description cannot transfer title to the office building on the property, then they never had any interest in that building. They have no interest here, and they wasted the court's time opposing Easy Homes' quiet title action. Now, I ask you to let me first assume that condo plat doesn't exist. Let's assume it does exist. It does. That doesn't change the outcome for them. There is no law that says recording one plat supersedes or invalidates any other plat. The law is that a plat is just a legal description put on a map. It's a shorthand form parties can use instead of laying out courses and distances or some other form of surveyor type of description verbatim on a legal description attached to a conveyance document, whether it's a deed or deed of trust. The condo plat just exists. It's outside of the relevant chain of title here. As I just said, the transfer from the prior grantor, the declarant that's identified on the 2005 plat, conveyed to Mr. Loiselle using the legal description referring to the prior 2003 plat. Essentially, Loiselle became a successor declarant. Loiselle received title to the land and anything that was on it. And at that time, there was a building on it.
Were there other owners? My understanding is that there were other owners within the condo.
Well, the record doesn't reflect that, Your Honor. The plat shows you that there's 3 different groups of declarants. There's a Lot 7A declarant, a Lot 7B declarant, and a Lot 7C declarant. There is no deed in the record showing any conveyance of Lot 7C, either to a property owners association or to individual unit owners.
Well, I guess what I'm getting at is, I understand you, but your contention is that the fact that this is set up as a condominium.
Correct, Your Honor. It is irrelevant to this case. It's an immaterial fact. The trial judge quoted in the minute entry granting summary judgment from ARS 33-1202, paragraph 10, which is the definition of condominium. And the second sentence of that, if my eyes will light on the right place of my outline here, that second sentence states, real estate is not a condominium unless the undivided interests in the common elements are vested in the unit owners. This record contains no deed showing any conveyance of the Lot 7C land to the owners association. There is an owners association. I have no doubt that what the prior or original declarants intended was to set this up that way, but they didn't do it. At least the owner of Lot 7C didn't.
So if there's no deed conveying common owners to the association, who owns the common owners?
The declarant continues to own it, and that declarant conveyed it to Loiselle, and Loiselle conveyed it to his trust. Then he conveyed it out of his trust. Then he conveyed it to, he conveyed it to his wholly owned entity, SFS Inc., and he signed the documents to put a $300,000 loan on it from Capital Fund, all using the same legal description. So, another way you can look at this.
Let me jump in.
Sure.
So you're saying, let's pretend, because since we started out, let's pretend that there's no plat. I mean, well, there's only a condo plat, and then there's a legal description. Say that they use a meets and bounds legal description as opposed to the amended plat that we have in front of us.
I'm sorry, you want me
So-
to assume there is a condo plat and no amended plat?
Yeah, no amended plat.
Okay.
Just a meets and bounds. Like there's a meets and bounds. It's like Exhibit A,
Yes.
meets and bounds, describes everything that the deed of trust covers, right? Just like you'd see in many deeds of trust. Just have
Yes,
a
if it was
meets and bounds.
rectangular, assume it takes point A corner all
Right,
the way to
but
B,
this
C,
is
D, and back.
triangular, and it would
Yes.
have to be worded as such, but that would make no difference. Right?
To my argument?
Right.
Correct, Your Honor.
Yeah.
If
Because
there,
it's just describing.
that's right. The failure to use the condo plat just means, or as the reference means, that the grantor in your example didn't convey using that legal description, conveyed using a meets and bounds legal description, the actual courses and distances that a surveyor would describe.
And explain to me one more time. So then, and if those two, assume that those two office buildings were there and are there, continue to be there, what's wrong with Mr. Arpad's argument that those are legally disconnected? They're legally above the beats and bounds description. That they're floating. If we're legally floating, they're vertically above it, so they're just simply not part of the meets and bounds description or the amended plat.
Well, Your Honor, I think what you've described would present a different issue than the one before us. So if you'll allow me to
Sure.
elaborate some. If we're just focused on what the legal description conveys, the recording of a condo plat followed by a conveyance using a description that's a meets and bounds description around the land would convey, if you're just interpreting the conveyance document, it would convey that land and everything that's on it. There might be a different issue, though, if there's been prior to that a conveyance of a unit as described on the condo plat before that. So if A owns the land and the building, there's really one building, it's a duplex building that's called 2 units. If A owns the land and the buildings, records the condo plat, conveys unit 1A to Mr. Arpad, and then conveys to me using a meets and bounds description as you're describing, if you're construing my document, it would convey everything to me because it's not a condo legal description. It's a meets and bounds description, which the interpretation, the law says is that's the land and any improvements on it. The different issue would be then, Mr. Arpad would say, okay, you may have a deed that says that was conveyed to you, but I already owned unit 1A, so you didn't get that. And that would be what a court would I presume do if you had those parties before it, and that's what it's trying to decide. We don't have that here. There is no conveyance of any of the units. There's no conveyance of the land, which actually under the condo plat, lot 7C really wouldn't even exist under that. It's tract A, which consists of all of lots, what had been lots 7A, 7B, and 7C. So if you were going to say, how would you make that conveyance, you would use the references as in the condo plat. In this case, that wasn't used. And I'm arguing that it's immaterial here because the only issue is what was conveyed according to the legal description that was used, and we don't have any third parties coming in and claiming I already had title to some part of that by a prior conveyance. We have the defendants, the group of defendants, Loiselle, of which only Blue River actually claims to be the owner now. But we have the group of defendants who got their whatever title they got using the exact same legal description. It's incongruous for them to claim that they own the duplex building. Based on their argument, they never owned it. So we shouldn't be here today.
And who did?
Who did what?
If you follow that line of reasoning, who would own it?
Well, if you're treating it as a question,
Never owned it. Who does? Is it available right now? Can I just go down and take it?
well, you might argue that the declarant still owned it, except there's also a subsequent quitclaim deed that my client got as part of in preparation for litigation from that prior grantor.
Yeah.
But that's not really the issue.
Title is lost, floating out, nobody holds it?
No, Your Honor. My answer was that the declarant would have still owned it, but there is another deed that
Right,
was
the but that
subsequently issued.
concerned it.
Pardon?
It was the but that concerned me. If the declarant still owns it, but
No. under that theory, you might argue that the declarant had not divested of title of the building. However, that's cured as a precautionary measure by a subsequent deed that was obtained as part of this litigation. But that's not how the case was decided because it wasn't necessary. And the only issue before you, I mean, I don't want to discourage, I understand you're looking at what's the broader implications of a ruling, but that's not what was presented to the trial court. The defendants defended on the basis that the legal description used did not convey the office building. And the argument I've presented here is there's more than one way you can defeat that, but it is defeated. There is no way for them to own the office building under their own theory. And to take another principle of construction, which is, first I want to say I'm not conceding there's any ambiguity here, but if there is, and you're looking at this extrinsic evidence, another rule of construction is if there's a reasonable construction and an unreasonable construction, you pick the reasonable one. And their construction is clearly unreasonable. Under their construction, they don't own the building either. And that may lead to your question of then who does?
Right.
And so my argument is, okay, I don't concede it's ambiguous, but if you're going to look at that, you have to pick my construction. It's the reasonable one. The reasonable one is also consistent with the undisputed facts about what the intent of the parties were. The grantor provided a declaration, the grantor to Loiselle, stating he understood or intended he was conveying the land and the building. Mr. Loiselle agreed in the stipulated facts that when Capital Fund insisted they wanted the security to be the land and the building, he agreed that he understood he was giving them security in the land and the building, and he's now trying to make an argument that he didn't do that. There's no support for that argument. Now, if there are more questions, of course, I'll be happy to answer them, but my final point of my summation here is that this has been a continuous, meritless effort to avoid the consequences of Loiselle's own loan default. He argued to you that he kept everything current, but I really don't know, because I don't think the record has what those, whether it was an interest-only loan or something, but it's undisputed that he didn't pay the loan off. So there is a default. He must be saying he made other payments on time, and it's not my client's fault, which is the purchaser at the sale, nor is it Capital Fund's fault he couldn't get refinancing. So all of that's irrelevant to this. This is a meritless effort to avoid the consequences of the loan default which led to the trustee's sale and the loss of the property. The appeal has also been burdened by the participation of defendants claiming no title interest in the property and their counsel's reliance on matters outside the record on appeal. Again, Blue River is the only one of the defendants claiming title, but all of them have been opposing this all the way along. So anticipating there are more such references in defendants' rebuttal here, I want to remind of my motion still pending before the panel that I object to any references to matters that were put in the record after the summary judgment ruling or the declaration that was filed with his reply brief that didn't even exist till then. Easy Homes is an innocent purchaser and should receive an award of its costs and attorney's fees along with affirmance of the judgment here. Thank you.
Opposing counsel talked about the stipulations, and again, this was filed for legal interpretation based on a stipulated record. The key stipulation that we relied on over and over again was paragraph 11, which in fact said that the condo plat created these new parcels. My predecessor counsel had no reason to think that that didn't solve the issue. The condo does exist. Counsel is here arguing still today somehow that the condo didn't exist when the conveyance happened. Yes, it did. It was stipulated. You can tell it if you look at the condo plat. There are no conveyances. Under the statutes, the declaration is a conveyance, and the declaration means all the documents, which includes the plat. For simplicity's sake, they only included the plat. My predecessor counsel had no way of knowing he should also include the declaration. I've asked you to take a look at that, and I'll add that if you feel you even need to. But in fact, in reality, it was stipulated that as of 2005, these parcels had been created. And that means the whole condo has to go in effect because you can't create vertical parcels until the condo goes into effect. So the premise Again, I would agree with opposing counsel that if all you had was flat descriptions, you can describe the outer boundaries and that conveys the stuff inside it. But that's not what we have. We have a condo where these vertically adjacent floating parcels are not conveyed by conveying the flat parcel underneath them. They simply aren't. Now, maybe there's an issue that nothing was conveyed. Maybe this is a nonsense legal description by the time you get a condo laid on top of this ground. I have to admit that my predecessor counsel said they bought the parking lot several times. What does that mean in this case? I don't know. I think you probably have to remand if you decide this case in my favor and say, we still own the condos. Okay, who owns the parking lot and what does that look like? We're talking about money now, so maybe there's a simple way to resolve that by just valuing it, because the property has in fact been sold and all we've got left is money in a court account somewhere to be divided up.
Counsel, move away from the legal descriptions for a minute. The deed of trust, according to Mr. Manhart, says that all improvements that are included on the property were subject to the loan. How is that not dispositive here?
Because
If
they are
dispositive on the issue of whether a reasonable person would be on notice to stop the sale.
a reasonable person would not be on notice, and in fact, there are stipulated facts in the record that people are calling the trustee and saying, what does it include? And the trustee is saying, I'm not going to tell you, don't buy this if you don't know what it is. And then the trustee only includes the flat parcel, not the other parcels.
But what does the plain language says? What would it be? What would all improvements be if it didn't include the offices?
It would be the gutters, the trees. Improvements on the flat parcel is whatever's in the common area once you have the condo created. That's what that parcel is. The buildings are no longer improvements. That terminology doesn't relate to the buildings at that point. It isn't a legal description of the buildings. It might be a vague colloquial description of the buildings, but it certainly isn't a legal description of the buildings. The only other thing I have, I guess, if that's all you have for me, I'd be happy to answer questions, but I think I made it very clear why I thought it was okay to introduce some things outside the record, request judicial notice and so forth. Made a proffer of things that would have been litigated below if we thought this was supposed to be an equity case, in which case I think that we wouldn't be here after a summary judgment. But keep in mind that Capital Fund was the one that wrote this deed of trust description. And the problem that you're confronting here is a problem that everybody from the seller who got together with these other folks to create a condo, and then they all cross-conveyed things to each other as part of declaring that condominium, right on up to the present, including my client, was unclear on what this description meant. And the title companies, frankly, were unclear on what this description meant. That's what we're here to try and clarify. And if you don't require, if you allow property to be sold out of condos, just by doing a meets and bounds description, you're creating all kinds of cases like this going off into the future. The condo plat itself says these parcels shall be described as they are in this condo plat henceforth. That's important.
Okay, counsel, thank you both for your arguments. We will take this matter under advisement and issue a decision in due course. Court is adjourned.